Here's a number I need you to remember, March 1st, 2026. Because if you are planning to file a premium processing request for your H-1B, your L-1, your O-1, your I-140, or your F-1 OPT work authorization, and that filing is not already postmarked before that date, you're about to pay more. Not just a little more. We are talking about a fee that is now creeping toward $3,000 for a single expedited processing request. And for certain situations that I am going to walk you through in detail today, paying that fee is not just smart. It is the difference between keeping your job, keeping your family together, or watching an opportunity slip through your hands because USCIS was still working through its backlog while your clock ran out. But here's the part that makes this more than just a story about a price increase. There is also an additional cost buried inside recent H-1B policy changes that almost nobody is talking about alongside the premium processing hike. And when you hear what it is, you are going to understand exactly why this channel exists. Stay with me. Welcome to Immigration Path USA, the clearest voice on U.S. immigration news when Washington is moving fast and the stakes are high. A quick but important disclaimer before we go further. I am not an attorney. Nothing in this video constitutes legal advice. This content is for educational and informational purposes only. Your case is unique, your timeline is unique, and you should always consult with a licensed immigration attorney or accredited representative before making any filing decisions. With that said, let's talk about exactly what is happening with USCIS premium processing fees in 2026, what these changes cost, when they take effect, and most importantly, when paying nearly $3,000 for faster processing is completely worth every single cent. Let's start with the actual numbers because the fee schedule has now been officially published in the Federal Register, and the effective date is confirmed. On January 9th, 2026, DHS issued a final rule adjusting USCIS premium processing fees to reflect inflation from June 2023 through June 2025, measured by the Consumer Price Index for all urban consumers. This is not a discretionary increase. The USCIS Stabilization Act requires DHS to adjust premium processing fees biennially to preserve the real value of the service. The rule is effective March 1st, 2026. Any Form I-907 postmarked on or after March 1st, 2026 must include the new fee. And USCIS has been explicit. If your Form I-907 arrives with the wrong fee amount, it will be rejected and returned. Not processed slowly, not given the benefit of the doubt. Rejected and returned. And when your I-907 is returned, you lose your premium processing timeline entirely, meaning your case goes back to standard processing, potentially costing you weeks or months, depending on your service center's current workload. So let's go through the exact new fee schedule because every dollar matters here, and you need to know the precise numbers. For Form I-129, the petition for a non-immigrant worker, covering H-1B, L-1A, L-1B, O-1, TN, E-2, E-3, and most other non-immigrant worker categories, the premium processing fee increases from $2,805 to $2,865. That is a $160 increase. For Form I-140, the immigrant petition for alien workers, covering employment-based green card categories including EB1, EB2, and EB3, the fee also increases from $2,805 to $2,965. For Form I-539, the application to extend or change non-immigrant status, which applies to F1, F2, J1, J2, M1, and M2 classifications, the fee increases from $1,965 to $2,275, an increase of $110. And for Form I-765, the application for employment authorization, which applies specifically to F1 students applying for OPT and STEM OPT extensions, the fee increases from $1,685 to $1,680, an increase of $95. Now I know what some of you are thinking, $160. That does not sound catastrophic. And you are right. In isolation, the dollar amount of the increase is not the story. The story is what this fee structure means in the context of everything else that is piling up on top of it in 2026. And here is something that dropped in September 2025 that has been underreported in the context of this fee hike. On September 19th, 2025, a presidential proclamation introduced a new $100,000 payment requirement, attached to new H-1B petitions filed on or after September 21st, 2025, $100,000 paid by the sponsoring employer. That is on top of the existing I-129 base filing fees. That is on top of the premium processing fee. That is on top of attorney fees. For any employer filing a new H-1B petition in 2026 and electing premium processing, the total cost of that single petition now includes the base I-129 filing fee, the $2,965 premium processing fee, the new $100,000 proclamation fee, and legal fees, all before a single decision has been made. That context matters enormously when you are evaluating whether premium processing is worth the cost. Because for most employers, navigating a $100,000 petition fee, an additional $2,965 for the certainty of a 15 business day decision is a rational choice. The uncertainty of standard processing, in that financial and operational context, is the more expensive option. But here is the catch that most people are missing when they think about premium processing. A lot of people think paying for premium processing means paying for approval. It does not. When you file Form I-907 and pay the premium processing fee, you are buying a guaranteed procedural response, meaning a decision, an RFE, or a notice of intent to deny within a statutory timeframe. For most I-129 and I-140 categories, that timeframe is 15 business days from the date USCIS receives a properly filed request. For EB1 multinational manager and EB1 extraordinary ability I-140 petitions, and for the EB2 national interest waiver, the premium processing window is 45 business days. For I-765 OPT and STEM OPT applications, and for I-539 change of status applications, the window is 30 business days. What premium processing guarantees is speed. What it does not guarantee is the outcome. If your underlying petition has weaknesses, if your documentation is incomplete, if your job description triggers scrutiny, premium processing will surface that problem faster. It will not fix it. This distinction matters enormously for anyone considering whether to upgrade a case that is not already well prepared. Let me now walk you through the cost-benefit analysis directly, because this is the question every employer and every foreign national deserves a clear answer to. When is paying nearly $3,000 for faster processing genuinely worth it? Scenario 1. The job start date is at risk. This is the most common and the most straightforward case for premium processing. Your employer has made a job offer to a foreign national. The offer is conditioned on obtaining H-1B status or an extension of an existing H-1B. The start date is firm. It is driven by a business need, a project timeline, a client contract, or a relocation deadline. Standard I-129 processing times in 2026 are running between 2 and 6 months, depending on the service center and the classification. If the start date is within that window and the consequences of missing it are significant, a retracted offer, a lost client, an unfilled critical role, the $2,965 premium processing fee is not a luxury. It is an insurance policy. The 15 business day decision window gives the employer and the employee certainty that they simply cannot achieve any other way. And in competitive talent markets, that certainty is part of the compensation package. Scenario 2. The H-1B extension is approaching expiration. This is where things can get genuinely serious. An H-1B worker whose current status is expiring and whose extension petition has not yet been acted upon by USCIS exists in a period of authorized stay under what is called cap gap or maintained status provisions. But those protections are contingent on a timely filed petition being pending. If the extension petition is pending and USCIS is still working through its backlog, standard processing may not resolve the case before the expiration on the I-94. In this situation, premium processing provides something that has very real legal value. It accelerates the resolution of the extension so that the worker's authorized status is confirmed, documented, and extended before ambiguity becomes a compliance risk. For any H-1B worker within 2 to 3 months of their I-94 expiration date whose extension has not yet been approved, this is not a situation where waiting for standard processing is advisable. Scenario 3, the F1 student on OPT facing a work gap. This is a scenario that plays out for thousands of international students every year, And the premium processing option for Form I-765 OPT and STEM OPT applications is specifically designed to address it. An F1 student completes their academic program and needs employment authorization through OPT before they can begin working for an employer that has extended a job offer. Standard I-765 processing times are running approximately 3 to 5 months. The new $1,880 premium processing fee compresses that timeline to 30 business days. For a student with a specific employment start date, an offer that expires if the work authorization is not in hand by a given date. Paying $1,780 to avoid losing the offer is not even a close call. It is the clear choice. And for STEM OPT extension applicants whose initial OPT period is running out while their extension petition is pending, the risk of a work authorization gap is directly tied to how quickly USCIS processes the I-765. Premium processing eliminates that uncertainty. This is where it gets critical for anyone with a dependent child approaching the age of 21. And I want every family in this situation to hear this clearly. In the employment-based green card system, a derivative beneficiary, meaning a dependent child included in an I-140 petition or an I-485 application, must be under the age of 21 at the time their green card is approved. After the age of 21, the child typically ages out of derivative status and must either qualify for their own visa category or leave the United States when their current status expires. The Child Status Protection Act provides some protections by calculating an adjusted age based on petition filing dates, but those protections do not eliminate the deadline. They reduce it. If you have a dependent child who is 19 or 20 years old and there is a pending I-140 or I-485 on your family's case, the premium processing option for the I-140 is not about convenience. It is about the difference between your child aging out of your petition or not. An I-140 premium processing request that compresses a 6-month adjudication window down to 15 business days could preserve derivative beneficiary status for a child who would otherwise age out during standard processing. That outcome is worth far more than $2,965 to every family facing that deadline. Let me give you a scenario that puts all of this in human terms. I want to tell you about a family I'm going to call the Kim family. David Kim had been in the United States on an L-1B specialized knowledge visa for 6 years, working for the U.S. subsidiary of a Korean technology company. His employer filed an I-140 petition for him in the EB-1C multinational manager category when he transitioned to a management role. The I-140 was filed without premium processing because at the time of filing, the employer's immigration counsel assessed that the standard processing window would resolve the case well before any status deadlines. Then the employer's Korean parent company underwent a restructuring. David's role was reclassified. His L-1B visa was coming up for extension, and there were questions about whether the extension would be approved under the restructured organizational chart. Meanwhile, his I-140 had been pending for 4 months with no decision. His daughter Jenny was 20 years old and 11 months. She'd been in the United States since the age of 9. She was a sophomore in college on an F2 dependent visa tied to her father's L-1B. Her ability to maintain status, her ability to eventually adjust through her father's petition, her entire future in the country where she had grown up, all of it was tied to timing. The family's attorney filed a premium processing request on the I-140. The $2,805 fee, the pre-March fee, was paid. 15 business days later, the I-140 was approved. Jenny's adjusted age under the Child Status Protection Act calculation was preserved. She did not age out. David had an approved I-140 and moved forward with his green card process. If that premium processing request had not been filed, if the standard processing timeline had played out over the remaining months, Jenny's age out would likely have occurred before the I-140 was approved, severing her derivative beneficiary status permanently. Now let me give you your 3-step action plan for navigating premium processing fees and strategy in 2026. Step 1. If you have a case ready to file that requires premium processing, evaluate your postmark date right now. The cutoff is March 1st, 2026. Any Form I-907 postmarked before that date uses the old fee to the $105 for most I-129 and I-140 categories. Any I-907 postmarked on or after March 1st must include the new fee. The postmark date is what controls, not the date USCIS receives the package, not the date you print the form, the date on the postmark, or the courier shipping label. If you are filing near the cutoff date, take a photograph of your shipping label before you drop the package off. Keep your shipping receipt. And understand that USCIS has explicitly stated it will reject and return any I-907 filed on or after March 1st with the incorrect fee amount. Even a difference of $95 is enough for rejection. Do not let a fee error undo your premium processing strategy. Step 2. Conduct a genuine cost-benefit analysis before adding premium processing to any petition. This means asking 3 questions. First, what is the concrete cost of a delay in this case? If the answer is a lost job offer, an expiring work authorization, an age-out deadline, or an H-1B status gap, premium processing is likely worth it. If the answer is inconvenience or impatience with the system, standard processing may be the right choice, particularly given that a fee approaching $3,000 is a real financial commitment. Second, is the underlying petition strong enough to benefit from premium processing? Remember, premium processing accelerates the decision. If the decision is going to be an RFE because the petition is underprepared, you receive the RFE faster. You want to go into premium processing with a petition that is ready for approval, not one that needs more work. Third, is the form type actually eligible for premium processing? Not every form and not every classification is eligible. For example, the I-485 adjustment of status application is not eligible for premium processing. Before paying the fee, confirm your specific form type and visa classification against the current USCIS eligibility list. Step 3. Understand the full cost stack of your filing before you budget for it. The premium processing fee is a separate payment from the base filing fee. It must be paid in a separate remittance from other filing fees, meaning you cannot combine it into a single check or card payment with your I-129 or I-140 filing fee. USCIS stopped accepting personal or business checks for most paper filings, so payment by credit card, debit card, or ACH bank transfer using the correct USCIS forms is now required. Get your payment method sorted before filing day so that a payment processing issue does not delay your submission near the postmark deadline. Here's the broader picture you need to hold in your mind as you make filing decisions in 2026. The immigration cost environment has shifted significantly between the new H-1B $100,000 proclamation fee, the rising USCIS base filing fees that took effect in April 2024, and now the inflation-adjusted premium processing increases. The total cost of a single employment-based immigration filing cycle has increased substantially. For small and mid-sized employers, that means immigration budget conversations that were straightforward 2 or 3 years ago are now significantly more complex. For individual applicants who are personally bearing some or all of these costs, the decision of when to use premium processing, when to front-load documentation to avoid RFEs, and when to accept standard processing timelines is a financial and strategic calculus that deserves real, careful analysis, not a default to whatever was done before. The value proposition of premium processing has not changed. The 15 business day guarantee is real, the certainty it provides is real, and in the situations I walked through today, expiring status, job offer deadlines, F1 OPT gaps, age-out scenarios, it is often the most important immigration tool available to you. What has changed is the price of accessing that tool. Know what you are paying, know why you are paying it, and make sure every dollar is going to work that is properly prepared, thoroughly documented, and ready to be adjudicated. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional, it's essential.